Thank you, Gordon. Thank you, friends in trademark law. What you have is a handout from me, so it's in the sleeve here. You have my talk in note form, and Florence has very kindly indicated that for those of you who like to look at a screen and be distracted, that she will scroll down to the correct paragraphs as I go through it. Okay, so the title to my paper is Provocative. The test adopted by the Grand Chamber is a reference to what I shall call the BSH, or the compressor case. I intend to be critical, but I hope constructively critical, and identify areas where I think there is still room for improvement and development in the jurisprudence of the Court of Justice. The points that I shall touch upon are, in my experience, points which matter very much in everyday practice, and they are points on which, when you find that you read a judgment of the General Court that goes in that direction, and sometimes on the same day you read another judgment of the General Court that goes in another direction on this question of similarity, I believe that the points I'm about to mention are the reason why the cases don't always coincide in the way you would like. Now, because I sit in a judicial capacity, I will immediately say that whatever I say, I reserve the right to change my mind. And indeed, if I change my mind as I'm speaking, I reserve my right to tell you that I've changed my mind halfway through my talk. Okay, so I start by way of introduction with the heading, which I put in inverted commas, how close is too close. As intellectual property lawyers, we all know that it doesn't matter what branch of intellectual property you are concerned with, 90% of the time you are always asking whether something is too close to something else, which requires you to consider the similarities and the differences, to attach significance to what you observe, and to come to a conclusion which you hope satisfies the test for legality. So, you know that from patent law, the patent versus the prior art, the infringement versus the prior art, the infringement versus the patent. Designs, it's a process of constant comparison. In paragraphs 2 and 3, I identify how I think there are factors of particular significance in trademark law with regard to availability of protection and scope of protection. Now, it doesn't take you very long in the practice of trademark law to understand that the availability of protection by registration for a trademark requires the sign to be distinctive. It must possess a distinctive character. By the way, there is still, even at this point in time, you could get very experienced trademark lawyers and judges in the same room. If you had 10 of them, you would still get 15 different views as to actually what the test is for determining whether something has the DNA to be distinctive or not. I like to use the expression origin neutral. I like to say that if something is origin neutral, it's not distinctive, it lacks distinctive, and by that means I avoid going into whether it's objectionable under the B clause, the C clause, or the D clause, or the shape clause, or whatever it is. So availability, you must have a distinctive character, we know that, basic, very elementary. When it comes to the scope of protection for trademarks, however, you can have protection granted to a sign, which is validly registered, which can be infringed by another sign, even though the other sign would not itself, considered in isolation, be a sign capable of protection by registration. So, in principle, something which would be origin neutral, considered entirely on its own, can still infringe the rights conferred by registration of a valid trademark. And the leading example of that is when you have a sign which has acquired a distinctive character through use. That's registered and protected as a trademark. The infringer will infringe even though in principle it might be said that his sign that he's using is not a registrable trademark, because there's a relative right asserted against him and he collides with it. Now, I identify in paragraph 4 what I see looking back. So looking back through the telescope from where we are now, what I identify as a turning point in the case law. This is where the Court of Justice insisted in the Adidas and Marcamod case, I think that was the second one in the series, identified that when you come to consider the relative rights for the purposes of infringement, you must tell yourself clearly that you're not engaged in the same exercise as you would be if you were considering whether the sign which the claimant is asserting was being examined for registrability. In other words, there is in principle a distinction between registrability and infringement, and part of what I'm going to say is that whilst that distinction does exist, we mustn't forget that there is frequently a crossover of concepts between the one environment, namely registration, and the other environment, which comes to the question of conflict on relative rights. Now, what did the Grand Chamber decide? First question, however, is why was the case in the Grand Chamber at all? Now, I don't profess to know the inner workings of the Court of Justice on allocation of cases to the Grand Chamber. I suspect that it was because at an early stage it was noticed that the appellant from the General Court was effectively requesting a reconsideration of case law. And I also suspect, again I have no reason to know, that there's also a perception and an understanding that there is a dialogue going on between the supervising courts in Luxembourg and the EU IPO in relation to the whole question of minimally distinctive signs and weak distinctive character. It is a topic that never goes away. So the signs that were in issue, the mark and the sign that were in issue, I identify them in paragraph 5. You had a device combined with the words, ordinary English words, compressor technology, written in ordinary small script, for use in relation to goods in classes 7, 9 and 11, and the earlier mark cited was, there were a series of them, mostly national registrations, featuring the word compressor, spelt with a K, and compressor plus. The opposition was to a very large degree successful. There was an appeal, and the interesting thing from an outsider's perspective is that the appellant didn't dispute that the goods in respect of which the opposition had succeeded were in part identical and in part similar, important concession, and it also accepted that the marks in issue were in a general sense similar overall. The plea taken before the Grand Chamber was that the decisions below were vitiated by error on the basis that the correct test for assessing similarity had not been applied. The argument was that the word compressor spelt with a K, and for this purpose it shouldn't matter whether the same point was made in relation to the word compressor spelt with a C, was descriptive of the characteristics of goods within the list of goods for which registration was requested, because they might include, in some cases at least, a mechanism in the form of a compressor, a pump, and that in any event the word itself was possessed of only minimal or weak distinctive character. Now, ultimately the argument, which was the ultimate argument, was always going to fail, which is to say that there is a rule, as if it's a rule of law, that where signs are of a low distinctive or weak distinctive character, that small differences always are sufficient to distinguish. Whilst that turns out in the laws of all the member states to be an everyday outcome, you can't say that it's a rule of law. It is always a matter of appreciation by the decision taker. Importantly and significantly, the Grand Chamber accepted that the plea was admissible. Why? Because it raised questions as to what the questions of legal principle, and was not simply intended to get a further redecision by the Court of Justice of the decisions on similarity which had been taken in the courts below. So the Court of Justice was prepared to accept that this raised issues of legal principle. However, the appeal was rejected on grounds which were located very firmly in existing case law. So to pick up some of the points, I've separated them out in paragraphs 10, 11 and 12. Let's just look at some of them together. In paragraph 10, you're seeing references to parts of the judgment which say things that we are very familiar with. Okay, so distinctiveness, distinctive character, is only one of the factors involved in the assessment, the global appreciation assessment. A likelihood of confusion cannot be precluded where the distinctive character of the earlier mark is weak. And even in a case involving an earlier mark of weak distinctive character, the general court may hold there's a likelihood of confusion. Now, in terms of statements, general statements, those comments are not in any way objectionable. However, there is something we need to remember. The Court of Justice has consistently said that the likelihood of confusion required by the legislation exists when there will be a perception amongst the relevant class of consumer that the goods or services in question come from the same or economically linked undertakings. Now, just hold that thought. In England, we would say, yes, the test for confusion, liability under the confusion clause, is not just confusion in the abstract, it's origin confusion. Because the way the test for liability has been formulated, coming from the same or economically linked undertakings, requires there to be, in some way, shape or form, origin confusion. And when you know, as I think we can safely say, it's an origin confusion liability, you know that origin confusion, hence origin, is linked to the essential function of a trademark, primarily, and you know that the essential function of a trademark depends upon its distinctiveness. So my comment generally at this point is that whilst those observations I've noted in paragraph 10 are true in general terms, we must never forget that the inquiry as to a likelihood of confusion does in fact, in the end, turn upon whether the defendant's sign, the opposite party's sign, has, shall I say loosely, captured the distinctiveness of the claimant's registered mark. Because if it doesn't succeed in capturing, even faintly, the distinctiveness of the claimant's mark, there shouldn't logically be the existence of a likelihood of confusion of the kind that the case law seems to require. Now, paragraph 11 is where I believe that the case law and the observations in it become a little contentious. You shouldn't disregard the similarity of the marks as a factor, basically, by preferring the factor constituted by distinctive character. So concentrate on similarity, and you mustn't substitute distinctive character for that. I question whether that statement can be regarded as, in any sense, a universal rule, for the reasons I've just discussed. The test for confusion seems to me to involve some degree of taking of distinctive character. Similarity is the stepping stone by means of which you come to that conclusion. I agree you must assess similarity, but I believe it's necessary to keep in mind that the reason you're doing so is because you're trying to see whether the one sign captures in some way elements of distinctiveness of the other. The second sentence that I've quoted in paragraph 11 I find bothersome. With regard to the monopolisation of a purely descriptive indication, it must be stated that it's not Article 8(1)(b), but the provisions concerning exclusion from registration on absolute grounds which are intended to avoid such monopolisation. Well, in procedural terms, it's entirely correct to take the view, of course, that an infringement action or a relative rights claim is not, in itself, the same as a procedure for invalidation of a registration. But as I've indicated earlier, I'm firmly of the view that there are concepts involved both at the registration stage on absolute grounds, and they reappear, albeit in a different way, in the relative rights context. So I don't think that it is anything other than correct procedurally to make this statement. I think the tribunals need to have a more open view about the concepts they're considering without trying to compartmentalise this as being an absolute ground, being a registration issue, and therefore that's entirely separate and we only now look at relative rights and we look at it through a different lens. I think that's too much too much compartmentalization. Now, the logical end point of this reasoning is in paragraph 12. And paragraph 12, I believe, this is known to those of you who followed it all the way through as basically the Formula 1, the F1 point. Right, so where you have an opposition based on a national registered trademark and the mark is registered, it's still registered, nobody's got rid of the registration. Even assuming that the earlier national mark is in fact descriptive in respect of some of the goods for which it's been registered, and then look at these words, and that its protection, so the protection of the earlier mark, leads to improper monopolization of the descriptive indication in question, such a consequence must be remedied, not by an application of Article 1b, excluding those goods as a matter of principle, but by invalidity proceedings. Now, I respectfully suggest that this is too legally formalistic. It's too heavily linked to a notion of compartmentalization between invalidity proceedings and relative rights proceedings, and I shall have a little bit more to say on that in a moment or two. Now, paragraph 13 is of course correct. You can't rule in advance that there is always and necessarily a rule that slight differences between marks are sufficient to preclude a likelihood of confusion in cases involving marks with a weak distinctive character. You can't make that a rule of law. At most, it would be what we call in England a rule of thumb. I don't know how that translates, but it's it's the kind of thing which commonly occurs. It accords with everybody's normal experience, but there is no black and white legal rule to that effect. In paragraphs 14 and 15 and 16, I've noted a recent case which has attracted a lot of interest. This was basically in relation to tyres, tyre manufacturers. You have the mark X, the single letter X, represented with a good degree of graphic stylization, but not a very large amount. And you have it alleged for conflict with the mark X-King, X-King, also represented with some degree of stylization. Now, the applicant, as I notice in paragraph 16, went to the Court of Justice and contended that there is a general rule derived from the case law that a single letter of the alphabet, irrespective of whether it's descriptive in relation to the goods in question, in itself constitutes an inherently weak element of a sign. Now, the court gave the only and obvious answer to that, which is such a rule is not to be found in the case law of the Court of Justice. I do respectfully beg to submit, however, the question was whether there should be such a rule in the case law of the Court of Justice, not whether there already was, because we know that there wasn't. So I rather think that terse statement was good enough to get rid of the actual argument that was put to the court, but a little bit more could have been said. So my next heading above paragraph 17, and you know where I'm going, is this approach too formalistic? Yes, I say, especially in relation to the Formula 1 point of the concept of deeming a mark to be possessed of a certain degree of distinctiveness simply by virtue of the fact that it's registered. When did anybody ever meet a relevant average consumer, or indeed any other normal human being, to whom the state of the register in a competent authority's files was a factor which affected their perception and recollections of a sign or a mark? Registration has nothing to do, as an administrative act, has nothing to do with the way that a sign is actually perceived. And I always like, it's a whimsical thing I cite whenever I get the chance, the famous passage from Ludwig Wittgenstein. For a large class of cases, though not for all, in which we employ the word meaning, it can be defined thus: the meaning of a word is its use in the language. Meaning is use. How perfect. He could have been a trademark examiner and risen to great heights. He could have been the president of this office for writing sentiments like that. Very good. Next question. Is the approach that I've just described, by reference to the case law, is it truly compatible with two things? And I call them the need to be compatible with those two things. First of all, to take account of the actualities of public perception of a mark at the relevant point in time, and secondly, to strike a balance between the interests of the proprietor of a trademark and the interests of other economic operators. Now, in the case law, you will find both of those views expressed as material considerations in the case of Levi Strauss and Casucci. Don't tell me, I already know that that was a case for revocation for loss of distinctiveness. The judgment was delivered within the framework of the legislation relating to acts or inactivity of the proprietor being the reason for the loss of distinctiveness. But those considerations, so the actualities of public perception of a mark at the relevant point in time and striking a balance between the interests of the proprietor and the interests of other economic operators, were positively identified as reasons to which the court attached importance in its judgment as to the status of the registered mark that was being sued upon. So you see that you have in paragraph 23, the court is speaking here, that's the Court of Justice. The proprietor's right to protection of his mark from infringement is neither genuine nor effective if account may not be taken of the perception of the public concerned at the time when the sign, the use of which infringes the mark in question, began to be used. What does that tell us? It tells us that whatever the state of the register may once have been, you're supposed to look as best you can at how people perceive and remember a sign as of now, today, or at the relevant date for the purposes of the relative rights claim. Then in paragraph 24, I quote the other segment of the judgment, in which they speak about the need to generally strike a balance between the interest of the proprietor to safeguard its essential function on the one hand, the proprietor of the trademark, and the interests of other economic operators in having signs capable of denoting their products. And I go further, why not the interests of other economic operators in having origin-neutral signs capable of describing their products and services? What's wrong with taking that into account as well? So the first thing I would say is, yes, I know that that was a case involving a claim for revocation, for loss of distinctive character. I know that there are special provisions in the trademark legislation which say that you only lose if it's you only lose your rights if the loss of distinctive character is as a result of your own acts or omissions, your own inactivity. I know that, but my plea is this. If those considerations are valid there, why don't we recognize that and generalize this concept? Because they are no less valid in the other areas in which relative right questions can arise. They're not purely registrability questions. So I want to put forward a controversial, no, it's not controversial. I want to put forward a very persuasive, blindingly obvious, correct solution that we should take account by analogy. You know that in the Enforcement Directive, so I speak of 2004-48, you know that there is a general obligation set out in Article 3.2 to ensure that the enforcement of intellectual property rights, and including trademark rights of course, must be effective, proportionate, and applied in such a manner as to avoid the creation of barriers to legitimate trade and to provide for safeguards against their abuse. Now, I know that the Enforcement Directive is generally understood to be about the enforcement of trademark rights in infringement proceedings, but we know, all of us know, that actually relative rights cases in the office, they are just infringement proceedings. It's the same concepts in another environment. I know that the examination in the office is dealt with in a certain administrative way. It cannot be the full inquiry of the kind that you will get in most member states' courts when there's an infringement action. But nonetheless, the assertion of a relative rights claim in the procedures of the office is no different in principle from the assertion of a relative rights claim in infringement proceedings. And so why don't we say, in relation to the proceedings in the office, that those same criteria must apply, that the protection that you give to the earlier registered mark must be effective, proportionate, and applied in such a manner as to avoid the creation of barriers to legitimate trade. That rule would require you to say to yourself, I must be careful not to give disproportionate protection to weak or non-distinctive elements or very low distinctive elements. The protection must always be proportionate. And by the way, even if I can't rely on Article 3.2 of the directive, the enforcement directive, unless the law has changed, proportionality has been many times over said in the case law of the court to be a fundamental principle of European Union law. And so eventually I always come to the proposition that if you give too much protection to marks which in the common current understanding of signs amongst the relevant consumers is weak or non-distinctive, if you overprotect them, you are giving disproportionate protection to the earlier registered right, and this is wrong in principle. Now, part of the analysis that we must confront here is that the word similarity is of governing significance in two ways. We know that for a likelihood of confusion to exist, in order to be objectionable, there must be similarity of signs, and there must be similarity in relation to goods or services, the goods or services in issue, so as a minimum. So we all know that you can have confusion, consumer confusion, in circumstances where there isn't similarity of the goods or services, not in the technical sense of the word. But it's clear enough, and the case law of the Court of Justice is very firmly on this position, and I see no reason to say they should think again about it. The only relevant confusion is confusion where you have the two dimensions of similarity, so similarity of signs and similarity of goods or services. Now, I will now break for a moment on my script and tell you about a case that I had to decide where there was a moment of insight, for me at least. The two marks that I had to take a decision on appeal were identical. The earlier mark was registered for, I forget which way round it was, but it doesn't matter. It was registered for legal services, and the mark applied for was for accountancy services. I realized as the argument went on that because of the way that certain professions are and are not allowed to operate in different member states, there would be some member states where the idea that accountancy services could be regarded as similar to legal services would not be a thinkable thought. They would not accept it. There would be too much specialization for the accountants and too much specialization on the legal services. In England, in the UK, that's not the position. You will very often find that accountants are providing advice in relation to tax schemes, arrangements, formation of companies, general commercial services associated with the provision of accountancy services. You will find them involved in the administration of estates, drawing up the accounts for inheritance or succession tax, and so on and so forth. And you will find, therefore, that there is a crossover. There's an area where legal services, many legal services don't involve anything of the kind that accountants do, and the opposite way round. But there's an area where you have two circles. So if you think of a Venn diagram, two circles which intersect. And so I said that there was similarity in the area covered where the Venn diagram overlaps. I said there was similarity. And then I realized that similarity has to be a matter of perception. It's not simply a matter of resemblance. And this is the point I would wish to press upon you. Too many times I read decisions of the General Court in which you see the analysis, they count the letters, they look at the similarity at the front end, they look at the absence of similarity at the back end, they ask whether it rhymes, and all of this sort of analysis. Yes, it has a role to play, but we are not robots. It's mechanistic. We are sentient human beings. We have brains. The average consumer thinks and understands. And for this purpose, it's not strictly resemblance that matters, it's relatedness, whether the perception of the consumer involves some conception that this is related to that. Do they have an affinity? Are they kindred to one another? I don't know how well these words will translate. So a good example I like to give, and I know I'm in the area of goods, is air conditioning equipment similar to refrigerators? Now, you could go around many of the offices in the European Union and they would say, no, air conditioning equipment and refrigerators are not similar in the relevant sense. But do you know, from a consumer point of view, indeed from your own point of view, if you bought an air conditioner and then you came to consider a refrigerator and the mark was identical or similar, you would think you were getting the benefit perhaps of similar technical expertise, skills and resources, and I believe it operates both way round. On the other hand, a simple proximity test is not enough, because an example they like to use here in the office is, if you take it too literally, you on the question of what is complementary to what, you could end up asking yourself whether ice cream and ice cream scoops for serving ice cream, whether they're similar or not. Now, the point about this is, I wish to press the proposition that we must not have robotic, mechanistic assessments of similarity, both in relation to signs and in relation to goods and services. The question is one of relatedness. That, by the way, is how it comes out in US case law, where they have considerable experience of applying this, and I think we must get away from the mechanistic type comparison. So what do I suggest? What I suggest is in paragraph 33. What we need is a realistic, by which I mean a real-world evaluation of what? The net effect, the end effect of the similarities and difference between the marks in issue and the goods or services in issue, giving the similarities and the differences as much or as little significance as the relevant average consumer would have attached to them at the relevant point in time. Now, to my mind, reading the case law, this is a perfectly adequate way, I would say this, wouldn't I, but it's a perfectly adequate way of giving effect to the global appreciation that you're required in all trademark cases to undertake, but it locates the whole of the exercise into the realm of perception, which is where I think it should be. Now, distinctiveness. This is one of the most remarkable things. Let me just check my watch. Right. So I had a colleague from England. This has become known in English law, amongst English lawyers, as the Leipzig Question, for reasons I shall now explain. My colleague went to give a talk to a very well-qualified audience in Germany, and he said, well, in England we have this approach. We adopt a strict view on surnames, where we don't like them, we're careful, we require distinctiveness normally, unless the name is unusual. Geographical, all these things, the geographical, the surnames, the colours. And so he gave this talk. And then a member of the audience put his hand up and said, well, thank you very much for that exposition, that was very informative. And I do definitely understand the reasoning why in the United Kingdom you refuse the registration of marks. And then he said, but can you answer this question? How do you decide whether you're actually going to put a mark on the register instead of refusing it? That's called the Leipzig Question. Now, I venture to submit that even at this moment in time today, so the legislation goes back 1994, 1995. You can do the arithmetic as to how many years have gone by between then and now. Do you know? Do you know the answer to the Leipzig Question in European Union law? What is the test? What is the DNA of the test? How do you determine whether something is distinctive or not? Right. Well, the first thing you need to do, I say, is to recognize that distinctiveness is a relative concept. As an attribute of identity in a competitive marketplace, the first thing you need to have is a horizontal view. So you need to have some understanding of how that mark that you're considering for distinctiveness, how it stands up against other marks in use in the competitive marketplace for related similar goods or services in the relevant economic sector, and without taking too narrow a view of what the relevant economic sector is. So there's a horizontal concept of distinctiveness as being relative, and then there is a timeline. And the timeline must never be forgotten. That which was distinctive 5 years ago, I was tempted to say 10 years ago, but 5 years ago is relevant enough nowadays. You've got no reason to assume without checking it that it's still distinctive now. And this is the great curse of that rule which says that you must assume that there is distinctiveness because the earlier mark was registered 5, 10, whatever years ago. I'm told, I haven't bothered to check it, I like to believe it without checking it because it was mentioned here in discussion, I think, on Monday. There are registrations in place for the word internet. They're still there. They're sitting on the register. Nobody in their right mind would say, well, I must assume that there is distinctiveness in relation to a registration like that in the year 2017. It's absurd. You couldn't think it. You'd be haunted by the ghost of Ludwig Wittgenstein. It's not possible to take that view. So, distinctiveness is a relative concept. Please, here's the problem. The great vast majority of cases that go up to Luxembourg, to the supervising courts, are decided in the context of examination in a registering office, the competent authority for registration. Experience tells you that the office here cannot conduct the full evaluation of practices in the market. It cannot conduct the full assessment in the context of the administrative procedures. They don't have enough time, they don't have enough resources, they can't actually go out and collect all the evidence that's necessary to do it. They use their common sense, but experience teaches you that when it comes to relative rights cases on the infringement side of it, when you have courts in the member states dealing with it, their assessments are much more grounded in the realities of the marketplace than some of the decisions which are forced upon the decision takers in the office system here. That means, to be candid with you, that the cases which, as an outsider to the Court of Justice, the cases which matter a lot more to me, I don't mean this that the others don't matter, but the ones that matter a lot to me are the ones which go on reference to the CJEU from the member state courts, because there's usually a docket, there's usually fact-finding, there's usually assessment, sometimes there's witness statements and evidence in full form, and therefore the Court of Justice is able to give what should I call a 360-degree vision assessment of these concepts. Whereas by the time the docket comes up from this office to the General Court and then goes up to the top court, it's all being conducted within the parameters of what people think they should take as their analytical starting point. So this is how you get these rules which are not rules, that generally people pay more attention to the front end of a mark than the back end. Well, maybe they do, but it doesn't tell you anything about the mark you're looking at. And these other rules of this kind. Now, a particularly interesting point is the one I touched on last, paragraphs 36 and 37. And I hinted at this earlier on in the exchanges we had. When it's a marvelous thing. It's extremely important for the Court of Justice to have done what it did. And it's a very important step that they took. I believe that the impetus for it comes historically from the opinion of Rita Rabo-Colomer in the Arsenal Football Club. It's always worth, if you have a moment, you're on a plane or something, you have a moment, it's always worth going back to the cases to see what you can see in them, knowing what you know now, because the influence of the Advocates General on the thinking of the court evolves over time. You don't see it at the time. You don't necessarily see it straight away when you look at the judgment relative to which the opinion was given. So Rita Rabo-Colomer says to say that it requires use of a mark as a trademark is almost to say precisely nothing at all about what is required for the purposes of a conflict. Oh, 5 minutes, right. And he says you must have regard to the functions for which the mark is protected by registration. And this is important, that the court has accepted that approach, and it's become stronger over successive cases since then. Why is it important? Answer, because if you look at, from memory, yes, if you look at Article 16.1 of the TRIPS Agreement, Article 16.1 of the TRIPS Agreement says that where there is double identity, the existence of a likelihood of confusion shall be presumed. Now, that point was presented four square for consideration by the Court of Justice in the Interflora and Marks and Spencer case on keywords, and I was there and I was arguing, and it was a very good interactive hearing in the Court of Justice, and you will see that there are references early on and then later on about the need to be preservative of fair competition. Fine. Now, the problem I have is this, that if you look at what some authors will write, you will find that there is almost no limit to the number of functions for which a trademark can be protected by registration. Sometimes you see commentary that suggests there are 20 functions or 17 or whatever. Well, actually, I prefer to look at something here and to ask this question, which is in paragraph 37. Should we? Can we? I say yes, we can, we should, and we must say that the reciprocal, the corollary of requiring adverse effect on functions is to create the possibility for saying, yeah, well, even if there is no defense within the limitation provisions, because those limitation provisions, you know, are not very good, there is still a defense which says I'm not interfering with the functions for which the mark is protected by registration, and that will open the door to the recognition within the EU of scope for a fair use defense. And I personally believe this can't happen too soon. Thank you.